The matric results publication case started back in 2022 when a judge ruled in favor of AfriForum and other parties, saying the release was in the public interest. The court also ruled that the use of examination numbers instead of the matriculants' names provided sufficient protection for their privacy. I'm now joined by Alana Bailey from AfriForum. Alana, a very good afternoon to you. Thanks very much for your time. Take us back, if you will, to why you are so insistent or so keen on these results being published, and not just being published, but being published in newspapers.
Thank you, Vuyo. Yes, as you said, we already had a case about the 2021 matriculants in 2022, where the judge issued an order to say that the results had to be published. And we started with that case at that time because a lot of our members and matriculants approached us and said that they really wanted to have the results published in newspapers for various reasons. But one of the most important reasons was exactly what Judge Tolmay referred to, that people in rural areas sometimes don't have connectivity, or sometimes people do not have the funding to have data, and for them it's important to have other avenues open in which they can get their results. So that was one of our main arguments at that time, and it is still an argument at this stage. So we hope that the court will rule in our favor tomorrow, and also in the appeal case, which will argue the merits of matriculation results being published, which will happen later this year.
I get the legal part. Let me digress a bit. I'm hoping that I'll be able to illustrate this point. Whenever we ask politicians to be accountable, and then they hide behind legal argument that it's not illegal or I reserve my rights, we then say you need to go beyond legality, to talk about ethics and other things, the consequences of your actions or the consequences of you being in your office given what you are alleged to have done, right? So in this instance, I'm saying well and good for a student who is going to pass, but that student who doesn't pass and who feels ashamed that they have disgraced themselves in front of their community, and they would rather the community not know or ask them first. Should we not avoid such things? And does the publication of numbers, student numbers, which will then still give the student, not suffice?
Well, the court and we agreed in 2022 that the use of numbers only already provides adequate protection for the identity of learners. So we felt at that stage that was adequate protection of their right to privacy. But then the Department of Basic Education is now also going a step further by instituting a program which started this year, but it wasn't fully functional. But I'm sure it's going to be in 2025, whereby they approach the learners when they register to write the matriculation exams, and they can then decide do they give permission to have their results published or not. So I think that will make it even a better system to keep privacy in mind. Then about the whole issue of people who do not pass and who are emotionally very disturbed by the fact that they didn't pass, I think the question we should be asking is what the mental health help that we provide to learners encompass. Is it sufficient? Do we have enough psychologists who can help people, or trauma counselors who can help people who do not get good results or who fail? Because I think even if your name or number isn't published in a newspaper, somewhere, somehow, the community will know that you didn't pass, and that same trauma is going to be there. So instead of denying the people for whom it's really important to know whether they passed or not, and who need access to their pass rate as soon as possible, to deny them that right, rather provide better care of people who are not happy about their results.
But people in rural areas, if I take your earlier point, many don't have access to newspapers anyway. And add to that the fact that many are closing down. Only a week ago, one of the major titles in this country is going to exist only online.
Yes, we're very concerned about the closing of newspapers because that denies access not only to the matriculation results, but also to news for many people. At least with news, they still have radio and etc. But I think there are many areas where newspapers do reach and where people are able to access it. And for them, it's really important to have that matriculation results available on print. And also other public media. This case seemed to have focused very exclusively on print media, but the case of 2022 also talked about public platforms. Like many newspapers had a number where you could register and you could get your results from them and not only from the DBE, which some people for some reason prefer. And I think that's the broader issue that has to be argued in the merit case, where we need to look at, do we have only one channel, the DBE channel, or do we in future have more channels, whether it is by SMS, by WhatsApp, by a site that you log into, or newsprint?
So you don't think it somewhat or in some way it kills your argument, the fact that many people in rural areas don't have access to newspapers anyway, the fact that titles are disappearing or remain only online, which also means issues like internet penetration, affordability of data, and all those things?
I think that every area has a unique offer, and the more avenues we have open that provide access to the results, the more we are sure that a learner who is in an area that is a bit more inaccessible will get his or her results in some way, whether it's from the school or online medium or the DBE line or a newspaper that is printed. So I think we argue in favor of the public interest that you should have a choice. There shouldn't just be one way in which you can obtain your results. And that choice should at the same time protect your privacy. So that's why we are in favor of using the exam numbers and not an ID number or names.
And what if, I know this is hypothetical, Judge Tolmay rules in favor of the regulator tomorrow?
If she rules in favor of the regulator, then the results will only be accessible either at the schools or via the DBE. But then the court case is in any way still going ahead. You will remember that on the 11th of November, the Information Regulator ordered or gave a directive to the Department of Basic Education not to publish. And the Department of Basic Education appealed against that decision. So that is a court case that has to take place later this year, and that will cover the merits of should it be published or should it not. And I think that's going to be a very interesting and a very important case, not only for matriculants, but also for other ways in which we work with people's private information. It's very difficult at this stage with the POPI Act to distinguish where public interest stops and where privacy rights kick in. And that case is going to take us a long way forward in determining exactly how we interpret the POPI Act.
But you will still be maintaining your position in the event that is Judge Tolmay rules in favor of the regulator.
Yes, and then we will definitely hope that the 2025 matriculants will be able to access their information in 2026.
We shall see. Alana Bailey, thank you very much for your time. Really appreciate it.